Parliament's Impeachment Committee has concluded that it will appeal last week's judgment by the Western Cape High Court that granted President Cyril Ramaphosa's bid to halt the committee. The judgment meant that it can only go ahead with the preparatory work like deciding on its terms of reference and appointing an evidence leader. No public hearings or testimony can take place pending a judicial review of the Section 89 independent panel report, for which will be heard early in September. The ATM, EFF, MK Party and the UAT have already approached the Constitutional Court to review this matter. All right, so let's bring in political analyst Professor Ntsikelelo Breakfast to weigh in on this matter. Prof, a very good afternoon to you, and thank you so much for your time. So, of course, the committee itself is faced with the prospect that no public hearings or testimony can take place pending that judicial review of the Section 89 independent panel report, for which it will only be heard in early September. So Parliament's Impeachment Committee now concluding that it will appeal last week's judgment by the Western Cape High Court. What does this all mean, do you think?
Unati, first of all, this is a very interesting turn of events. I'm not taken aback by it. I must say that I saw it coming because part of me thinks that, the judgment is questionable. I also took it with a pinch of salt. So I think for the court to concede that the president is going to suffer reputational damage, it beats me. It doesn't make sense to me. So that creates a scope then for this legal action that is instituted to basically make the Constitutional Court to have a change of heart or to re-examine that judgment. But I think we cannot rule out the possibility that we might get a new judgment as opposed to the one that was delivered last week on a Friday.
You've got all these political parties, the ATM, EFF, MK Party and UAT, now approaching the Con Court to challenge, Ramaphosa's interdict process, citing, amongst others, a separation of powers principle. What do you think the court is being asked to do here? Especially when you consider that this case seems then to place the judiciary, parliament, and in fact even the presidency on this difficult path of defining clearly that separation of powers.
So for me, there are two main lines of arguments. On the one hand, I think the rationale behind the argument by Parliament and other political parties is to make sure that Parliament is allowed to do its work in terms of demanding answerability or accountability from the head of state, because that is one of the roles of Parliament, not just to make laws, but it is to hold the executive institution accountable. So I think on the one hand, Parliament wants to do that, but also on the other hand, you have a culture of human rights, and the president also enjoys those rights. So I think that balance will only be struck by a court of law. I think that is the rationale behind this legal action then, to solicit for the audience of the Constitutional Court to make a call. And the beauty of it is that after the call has been made, there is no other avenue now to request for another re-examination of this. So after the Constitutional Court has made a call, the dust will then settle.
Yeah, some critics are suggesting why not wait until September. So what this Western Cape judgment meant is that, the Impeachment Committee can only now go ahead with the preparatory work like deciding on its terms of reference and appointing an evidence leader. That process, the latter, was extended. What can we then expect over the next while to see in as far as that is concerned, in as far as the evidence leaders that should ultimately be appointed?
Yes, the judgment does not imply that the work of the committee has been put on hold. But as you indicated when you were setting the scene, it simply means that they cannot hold hearings and then call people to come and testify, which is putting the committee, by so doing, on the back foot. But also I think it is good that Parliament has taken this legal action to make sure that they identify the gaps of the judgment, not to throw away any cold water or anything of the sort. I just think that maybe the reason why the judgment was in favor of the president could be on technical grounds or the manner in which the argument was pitched, but I don't understand how the judge arrived at that conclusion to rule in favor of the president, because I don't think that President Ramaphosa, in my opinion, instituted the legal action in good faith, because if he had done so, he would have instituted that legal action at the time at which the story broke in the beginning. He did not do that because at that time the ANC had the a majority and he was banking on that.
Well, in fact, one judge was in favor of Parliament. But Prof, thank you so much for your time. Really do appreciate it. Professor Ntsikelelo Breakfast just weighing in on the latest developments there.